The decision to fix, sell, or close a company that is treading water in the printing, graphics, and mailing services industry is never easy. And one particular challenge is how to negotiate personal guarantees. I recently got a call from an owner who said, I have no options. I can only stay in business and keep paying the debts because otherwise creditors are going to come after me on my guarantees and I'm going to lose everything or I'm going to have to file for bankruptcy. Hitting pause on that talk track, I offered a different approach. I said to the owner, what would you say if we could make an amicable settlement that does not involve losing everything or filing for bankruptcy? And the response was, sure, I would love to, but I can't because I have all this money in the bank. I own my own home and there's equity in it. So why would a creditor ever settle with me? They're just going to come after me. That's when I said there's more to it than meets the eye. And let's dig into what are the three variables that will determine if there's a viable pathway to settlement. And remember, this is not talking about getting out of a guarantee. I'm talking about making an amicable settlement. There's three variables. Number one, legal. Number two, collectability. And number three is timing. As far as the legal liability, that's often the most challenging. That's not as easy as it may seem. Many lenders and the borrowers do not agree on what is the amount of the debt. Now, why is that? Because sometimes loans or leases are sold to second and third purchasers, and often the paperwork and the backroom accounting does not travel well during that transfer of the ownership of the loan or the lease. So the starting point is to dig into the legalese of the documents that were signed and follow it forward to determine what is legally owed. The second step, that's the one about collectability. So back to the owner who said, I have cash in the bank and equity in my home, therefore the creditor won't settle. I will acknowledge that collectability is certainly one of the factors. And if you're collectible based on cash in the bank or equity in assets, that does not mean that settlement can't take place. It just means that that one variable is not as favorable to you as perhaps the others. So we have to look elsewhere. And the third variable is where that's where the secret sauce is. It's in the timing. And the timing is a function of how long the personal guarantee has been in existence with that particular lender, how long the debt has been in default, if it is in default, and most of all, it has to do with how does it scorekeep on the books and records of the creditor. Their companies are not only looking at being able to collect, they're also looking at how it presents to their ownership and to regulators and stakeholders such as shareholders. So there's complicated internal analysis that creditors do that have a great bearing on their willingness to accept some form of an amicable settlement. So what this all means is that an owner of a treading water company should not feel stuck. Rather, it really should be a situation where they reach out for professional expertise to consider the options. Those options tend to go in the direction of making an amicable and fair settlement as the way to get out from under. Now, where does this come up? This comes up in the context of bank loans, merchant cash advance loans, credit cards, landlord obligations, and often personal guarantees that were extracted by key creditors during the survival period. Each of these type of personal guarantees are treated a little bit differently and then put under the lens of the legal collectability and timing matrix. I hope this gives those in the audience a fresh opinion as to what to do with personal guarantees when the business is treading water.